Welcome all speakers and participants to the final webinar of our Bracewell Dubai Week, how to make informed performance bonds and international arbitration decisions in Dubai and in Saudi. With me here today, I have two guest speakers who will be featured in the second half of the program. Olena Voronovych, who is the acting registrar with the DIAC, and Christian Alberti, who is the general counsel and chief of ADR at SCCA. Ibrahim Siddiki, resident partner here in Bracewell's Dubai office, will be part of the second part of this program later on as well. The first half of the program, I will be speaking with Rob Meade, an international disputes partner in our London office, as well as Tom Swarbrick, who is a resident partner here, also in the Dubai office, very often involved in project finance and construction and infrastructure focused. We will talk today about the full life cycle of a performance bond, from the negotiation through the calling into the arbitrating of a performance bond. We will be informed by Bracewell's experience, not only in the construction and infrastructure sector, and obviously the project finance work where this arises, but also our energy spectrum from the oil and gas through the power to the renewables. We will also address, as the title of the webinar suggests, the geographies of Dubai and Saudi Arabia, albeit that especially my partner Rob Meade has also had experiences going beyond these two geographies when it comes to performance bonds. So with that, welcome to the first part, the performance bond life cycle. Tom, what do we mean when we talk about performance bonds? What are performance bonds? Can you get us up to speed?
Sure. So listen, let me start off. I will describe very simply, and apologies to everyone on the call who has experience of this, but I want to make sure that we don't leave anyone behind before we get to the sexiest stuff that the disputes guys will talk about. So a performance bond is a type of security instrument used to support performance under a contract. So A agrees to perform a contract with B, and C agrees to guarantee or back up A's performance. So as Martin mentioned, I'm a construction lawyer. I draft contracts, energy, infrastructure, variety of asset classes. And we see performance bonds on pretty much every contract that I do, regardless of sector, regardless of jurisdiction. And in a construction context, a developer or employer engages a building contract to construct an asset, and then the building contractor will provide a performance bond from usually a bank or an insurance company. And then if there is a failure of the building contractor to perform, the developer or the employer can claim from the bond a sum of money to make up the failure.
Right. You've already addressed the on-demand and or conditional performance bonds subject, I believe, by saying that a bank and or an insurance company would issue the bond. Do these terms go hand in hand with each other?
So, good question. So, let me start by saying, so the construction industry refers to guarantees, and that covers on-demand bonds down to what we call conditional bonds. And so in terms of what those are, I like to think of it in terms of liquidity. So when you have performance security under a contract, and this is in construction or anywhere, I think it's helpful to think about in terms of liquidity, by which I mean, how easy is it to turn that security instrument into cash? And so at one end of the scale, you have security which is totally liquid, which might be, a suitcase of cash given to you by the contractor, and they say if anything goes wrong, take the cash out of the suitcase, and obviously that's very liquid. On the other end of the spectrum, we have a parent company guarantee, and that is not liquid because in order to extract cash from that parent company guarantee, you have to claim under the contract in the first instance. You don't succeed, you claim under the parent company might refuse the claim, you might have to go to arbitration, then you might have to enforce the award. So you can see that to get your hands on the cash for that instrument might be a very protracted process. And then somewhere in the middle, you have on-demand bonds and conditional bonds. And on-demand bonds are at this end of the spectrum, very liquid form of security. They're very straightforward documents, 2 pages long, usually provided by a bank, sometimes by an insurance company. And to convert that to cash, in theory, you should take your on-demand bond to the bank, present it, and 2 or 3 days later, out pops the cash. Conditional guarantees are a bit different because, as the name suggests, there are usually conditions that you have to demonstrate in order to get your hands on the cash. So you have to prove, for example, probably a breach of contract, which you shouldn't have to do under a genuinely on-demand form of bond. Or you have to get an arbitration award to take to the bond provider to say, this is evidence of my entitlement.
Right.
So,
over time,
one final point on the on-demand point, you can see, because it's so liquid, it's not an attractive instrument for contractors to have to put up, because any sign of a dispute, whether the contractor agrees with the claim or not, the employer always has the ability to go to the bank and get the cash without even having to demonstrate a breach of contract.
Right. I mean, and these instruments obviously hit the balance sheet depending on what point in time you look at them very differently. But I mean, just it would be fair to say that the odds are an on-demand bond is something that a bank underwrites, and the conditional bond is something the insurance company underwrites, or do we see mixtures thereof, so that by means of distinguishing them from the institution that issues them, it doesn't necessarily mean the consequence that it's one or the other.
Sure. So again, fantastic question, and they are relevant, and these are the things that we walk through with our clients when we're talking about bond coverage on a project. Because let's say I do a lot of project finance work, and in that world, banks and developers need the on-demand bond to be highly liquid. So for that, you probably need to go to a bank, and there's sort of two elements to it. There's the legal element, and there is case law around whether an instrument which is provided by a bank or an instrument provided by an insurance company, and the implications of the nature of the provider for the nature of the bond. And in general terms, as ever under English law, nothing's ever absolutely clear cut. But in general, the starting point is that if there is an instrument from a bank which says it's a bond, then you could safely assume that's an on-demand instrument. If it's provided by an insurance company, your starting point is that it's a conditional instrument, and therefore less liquid. And then the commercial part of that is that banks are in the business of paying out against security instruments. If you think of letters of credit, on-demand bonds, you present to the bank and they will pay out. And there are reputational considerations. If they don't pay out, then that will make it more difficult for them to sell these financial instruments in the market. Insurance companies, on the other hand, don't pay out, and in fact look for ways not to pay out. And I'm sure everyone on this webinar, if you've made claims against your home insurance or your car insurance, you know the process. You put in your claim to the insurance company. They say, well, we need evidence of damage, and we don't think your iPhone was worth that much, and you have that back and forth. So it is important, and it will affect the liquidity of the instrument and how easy it is to get your cash out at the end.
Right. So on the projects that you've been seeing, we talk about banks and insurance companies in general now. Do you see owners demanding only certain banks? Do you see other owners demanding only certain insurers? Is the identity of the issuer oftentimes a subject of contention amongst the parties when they negotiate?
So honestly, in the project finance world, there's not a lot of wiggle room. Banks have very stringent requirements. And the banks and the developers want to get their asset to a point where it's revenue generating. And if there's an issue on a project, then they want to be able to sort that out quickly. So they need a very liquid form of security from a reputable bank with a good credit rating, so they know they're going to get hands on the cash. So in the building contracts, you often have specific requirements. International banks, reputable banks of a certain credit rating. Now, there've been difficulties, honestly, in the last 3 years because of COVID and Brexit in the UK and Ukraine around credit ratings. And in the UAE, some of the local banks, frankly, aren't at a credit rating which international lenders consider is bankable. So you certainly have some discussion around that. But there's no wriggle room on on-demand versus conditional bonds, really, in a construction contract on-demand bond. That changes, by the way, outside of a project finance context. If you're doing office redevelopments or more straightforward construction, then developers might take a view that they don't need the liquid form of security. They don't want to incur the cost of that. So a more conditional instrument from an insurance company, which is cheaper, might suit everyone a little bit better.
Right. So breaking this down even further in the cross-border context, which then oftentimes may lead to international arbitration, but so in the cross-border context, does it even boil down to who the correspondent bank is that is being used, and different spin on it. Does the location of the project inform the negotiation of the performance bond regularly? So again,
I'll talk through project finance. So we're doing projects in Qatar and Saudi. Typically the bond providers are international banks. That's generally the requirement. But just for everyone's benefit, so the correspondent bank arrangement is that, for example, the bond provider might be HSBC in London. The project's located in Qatar. Everyone wants an ability to go to a bank in Doha and call upon the bond. And the function of the correspondent bank is really a post box. Might be a local bank where you can serve your demand. They put it into SWIFT, which is the interbank communication mechanism. The message goes off to HSBC, who wire the money back, and it pops out of the correspondent bank. So that's how that works. And in terms, so by and large, these bonds, you can see they're kind of offshore. So you have a project physically located in Doha, but the bond is held and the proceeds are coming from offshore. So in that sense, the location of the project is not important. Where it might be important is if you've got a Qatari project with Qatari banks, Qatari developer, Qatari contractor, with the issue of a bond from a Qatari bank. And in Qatar specifically, I know we're probably more interested in Saudi and UAE on this call, but Qatar have a prescribed form of bond for that scenario, which is more on the conditional side. So in that sense, and I know UAE have looked at implementing something similar, but there are jurisdictions which sort of legislate for that more for that specific conditional instrument.
Right. I mean, as a disputes lawyer, we get involved when disputes arise very often on whether calling the bond is actually due and performance is owed under it, and sometimes local courts get involved, but we'll get to that part in a little bit, especially with Rob on here. Just to give a sense on the practical impact of this particular piece on negotiating, the project finance, is this ever an issue where an owner has, demanding conditions that contractors simply, can't perform under? Is this sometimes even a reason to walk away from a project, or does that usually get resolved in practice? And then frankly, resolved without putting money into escrow or even instruments such as cash retentions or anything that really hits the balance sheet right away?
So speaking frankly, in a project finance context, everybody knows from the start you're going to need on-demand bond. All the projects that we do are on that basis.
Right.
And where it gets different is if a good example is the UK market. So I mentioned a while ago that on-demand bonds are obviously not very attractive for contractors because it's ready access to cash which they have to pay for. And often these bonds in the background are what they call cash collateralized. So the bond provider, the bank, will provide the bond, but to support that liability, the contractor has to deposit cash for the value of the bond in with that particular bank. So that's not an attractive proposition for a contractor. And in fact, the market in the UK is self-regulated, not the outside of sort of projects, but the real estate development market in the UK is self-regulated, such that now you cannot get an on-demand bond in the UK market, and everyone knows that. The bonds that when I was doing that work early in my career were all conditional. So you do get instances where an on-demand is not possible, and then you're right. Somewhere in the middle, in the oil and gas world, for example, without any project financing, you might have a debate about on-demand versus conditional. There might particular contractors working in new jurisdictions might have particular concerns. So to give an example, which I came about just yesterday, doing a project in Somaliland, the contractor wants to provide a bond in front of our client to our client's UAE entity because for some reason that is cheaper than providing it to the client's Singapore entity. So, and our clients, thinking about how they can make that work. So you do get some discussions. I would say it depends on project finance or not project finance, oil and gas sector versus real estate development sector.
Right. So overall, if you had to put a label on it, I mean, technicality versus deal breaker versus solutions are evidently being found.
I would say you get what you pay for, and
Okay.
people in project finance will pay for the security of a liquid instrument, and in real estate where the margins are lower, everyone is more inclined to take a view because that saves the project money if you don't have the gold standard.
Right. Yeah, and then segueing this into the world of disputes, how much time do you spend defining the conditions on the bond upon which a call can be made? I mean, is this something that really forces you to take the red pen out, or is this something usually dictated by the owners of the project and the financing behind it?
Yeah, so an on-demand bond is a very straightforward instrument, and that's not to say that you shouldn't be very careful when you're drafting it. But when you look at a bond, you can get a sense straight away of whether it's on-demand or conditional just by the length, because an on-demand bond will be 2 pages maximum. As soon as you start having language that you might see in parent company guarantees or language around having to demonstrate breach of contracts or whatever, and the bond starts to get 3, 4, 5 pages long, then you have to, you immediately on notice it's conditional and you've got to think about it more.
Right. Yeah, which is usually the turf of disputes lawyers to then, go harvest on.
I was just going to say, Martin, just on that point, you do have to think of the bond and what's in the bond, and we'll come on to this in a little bit, but you also have to think about what's in the underlying contract, whether there's any conditions in the underlying contract that may preclude a call as well.
Spot on. So that's something you would look at very closely before you would start recommending the enforcement of a bond, Rob. Is that right?
Certainly. I mean, if you're in a situation where you're thinking about the bond and thinking about making a call, you obviously need to look at the terms of the bond itself, but you also need to look at the terms of the underlying contract.
Right. What happens if there's disagreement, flat out? I mean, I thought bond is that ultimate instrument, naively speaking now, that would provide for that security that you don't have that dispute. Isn't that the very reason we put performance bonds into contractual arrangements and projects?
Yeah. So as Tom has explained, that is exactly why bonds are there. It's meant to be liquidity, quick access to cash. But Martin, you and I are both disputes lawyers, and so we're probably fortunate that when a bond is called, genuinely someone disagrees with it, there's a lot of money at stake, and so someone is going to try and challenge that call. Generally, how they do that will depend on when they find out about it. Do they find out in advance, maybe because there's a notification requirement in the underlying contract, or do they only find out when the bank picks up the phone and says, "Hey, I've just been served with a demand"?
Right on. And then the question is, do I need to appoint an emergency arbitrator, or do I go to a national court and seek injunctions?
Again, a very good question, and I think stepping back, it probably depends on what you're trying to achieve. So if you are trying to achieve the employer, the beneficiary of the bond, actually issuing a demand, actually making the call, then you may find you have to go down the arbitration route, because that may be baked into your underlying contract between the contractor and the employer. Obviously, we've all seen arbitration agreements with a carve out for going to the national courts for injunctive relief, but certainly you need to look at that wording and see what's permitted and what isn't. And if you do have that carve out, then you need to think about where's beneficial. What's better? Should I go to a national court or should I go to an emergency arbitrator? And interestingly, there was an English court case last year where the English court acknowledged that the test may be slightly laxer in emergency arbitration than before the English High Court, for example. But if you only find out after the demand's been issued and you essentially get a phone call from the bank saying we're processing it, then you may want to go and get an order that stops the bank paying. Now, the bank will not be party to the arbitration agreement, so there you're probably in the national courts.
Right on. Yeah. I mean, we keep speaking about, largely the bank. I mean, this is probably the more often a type of issue you see, especially on the on-demand side, and the contractor. But let me throw the very common subcontractor into this math. How does that impact? I mean, both ends. I mean, Tom, when you negotiate them, and Rob, I mean, as a contractor, my bond gets called upon, but it's my subcontractor that hasn't performed in time. What do I do now as the contractor?
Well, from a developer's perspective, I don't care what's going on below the EPC contract level. We call the bond, and then it's up to the EPC contractor to work out how it then backs that off down its supply chain. So, I guess if you've got a gold standard performance bond for your EPC contractor, ideally the EPC contractor would have some bond coverage, very high standard of bond coverage from their subcontractor, and they will in turn make the call down the chain. Now, I suspect in practice, as you go sort of further down the supply chain, that contractors take more of a view on it because, as I said, you get what you pay for, and so you can reduce the subcontract price and the subcontract price by getting more conditional bonds of lower amounts, and you might even take a view that you don't even need a bond.
I see. So Rob, would you agree then that especially on the level of the owner or the developer and the contractor's level, you have a resolution to the dispute, at least initially, but it does accelerate dispute between, say, the contractor and his or her subs, right?
Yeah, I mean, taking Tom's point as the owner developer, you don't necessarily care what's going on between the contractor and the subs, as long as you're getting your cash security from the bond. And then on your point, Martin, if you're calling a bond, there is a dispute of some nature, because you wouldn't be calling it otherwise. And it's almost inevitable that dispute will either eventually settle or eventually go to arbitration. But when you call the bond, there's a relatively high chance you'll have a satellite dispute, which is the injunctive relief piece.
Right on. And didn't you have actually a case that then featured in the courts of South Africa?
Yeah, so we had a case, it's been running for a while, but it was last year that the injunction application was made. And it was a power station in Africa, a power plant construction project, which was being project financed. And the bond was called by the employer. And actually, the first time the bond was called, an injunction application was issued in the South African courts on the basis that the bank paying out was a South African bank. And so the South African courts had jurisdiction. That was notwithstanding the fact that the bond was English law and provided for English court jurisdiction. So we ended up before the South African courts. And actually, the first time it's settled, calling the bond can sometimes be good leverage to reach a settlement. So an agreement was reached. A few months down the line, same position again. And that time we actually ended up calling and going all the way through the process of the injunction. And the South African judge basically threw out the injunction application and said, no, it's an underbarn bond. There's no fraud here. So the bank pays.
Right. And it's just taking this kind of project down the road now. I mean, if money actually flows under the bond, doesn't it have to be accounted for? Is this another fighting ground, years later at the completion of the project? I mean, or how do we get there? I mean, in between the calling of the bond, performance under the bond, and the project continues, immediate accounting, what happens?
Yeah, so let's say you call the bond, you have a dispute, you call the bond and you get the money. Now you still have a dispute, an underlying dispute, and that will proceed under the contract, according to the DRP, the dispute resolution procedure. If at the end of that process, it turns out that you've lost on the underlying dispute, that basically meant that you weren't really entitled to call the bond, because you may have said, well, I'm entitled to X many days of delay, damages in this amount, and so I'm calling the bond in that amount. But if it turns out you weren't entitled to that delay, then yeah, you've been enriched. So in theory, at least, you have to pay it back with interest, and you probably have to account for any damages. I say in theory because obviously if there's an express clause in the contract that requires you to pay back any overpayment, then it's quite clear. If there's no such clause, then you have a contractor making arguments about implied terms, potentially, going after equitable remedies, and it gets a bit murkier. But I think the starting position should be, if you've called it wrongly, you've been enriched and you have to pay it back.
Right. So you mentioned a case that then featured in South Africa in the courts. And help me, it was the underlying EPC subject to arbitration in London?
Yes, I think that one was ICC arbitration in London.
Okay. And did anybody raise the arbitration defense in the proceedings in South Africa?
They did not, no. So jurisdiction in South Africa wasn't challenged. I think the argument initially, certainly from the contractor, was essentially that because the bank's in South Africa and the bank isn't party to the EPC contract with the arbitration agreement, that it's not relevant. And our client was quite happy to go along with that in the circumstances.
Got it. Yeah. Okay. So when you advise in this context, Rob, I mean, what specific arbitration considerations do you consider? Let's say you advise the contractor.
Yeah, say you advise the contractor.
Indeed.
So okay, you advise the contractor. So you've had a bond call either about to be made or has been made. So I think the first consideration is, where's my action going to be directed? Is it against the party that's called the bond, the employer, which is my counterparty, or is it against the bank that's going to pay out? Now, if it's against the employer, then I think you're looking at your contract to see, well, have they done everything they should have done under the contract before they made the call? Did they have to give notice of dispute? Did they have to give notice of bond call? Did they have to start any, well, maybe not start arbitration, but start running some sort of conciliation process first? And then before you hit launch on your injunction application, you need to make sure you're going to the right place. So are you required to go under the institutional rules to, maybe an emergency arbitrator to get your relief rather than the courts? And as I think I mentioned a while ago, there has been this suggestion that emergency arbitrators may apply a laxer standard. So if you have a choice, and if you've got time, I think time is key, because in my experience, it's quicker to go and get injunctive relief from a court, particularly an English court, than maybe an emergency arbitrator. But if you have time, are you better off going down the arbitration route?
Right. And so you would try to enjoin your issuer, your bank, from performing under the bond that has been called upon by, say, the owner. Have you ever seen an alignment of the dispute resolution clauses between the issuer of a bond and you as a requesting contractor? And as well as the underlying project contract, or isn't this typically something that goes different ways?
I haven't actually. No, in my experience, the construction contracts, the EPC contracts, tend to provide for international arbitration, whereas the bonds tend to provide for exclusive court jurisdiction. So you don't tend to see that crossover.
Yep. Even the 15-day rules in prominent arbitration institutions on emergency arbitration at times aren't quick enough.
Yeah, they're not quite phoning up a high court judge on a Friday night and getting a decision in within a couple of hours. So,
see. Do you have any Saudi experiences on this, Ibrahim?
So yes, so I actually was working on a matter where we were advising a Saudi counterparty that was defending an enforcement of a foreign arbitration award, which was issued by GAFTA in the UK, which is I believe, the Grain and Food Trading Authority, and it was difficult to enforce the arbitration award. After various back and forths, 2 years, the arbitration award was finally enforced by Saudi courts.
I see. Okay. I think we have a question in the Q&A. What about the risk of an SOE, i.e. a Chinese EPC, state or enterprise, issuing bonds from Chinese banks? Is there any serious liquidity risk, and how do you get around this? That's the question. Any volunteers? Tom?
Yeah, I mean, that has been an issue, actually. So in the Middle East, we've done a lot of solar work, and the story of the last 3 years in the Middle East has been the influx of Chinese EPC contractors into the solar market, because they produce all the modules in China and they're the cheapest by a long way. And so with that influx has come, the first proposal from the contractor in terms of bond providers are Chinese banks based in Shanghai and Beijing and what have you. And it is challenging because, the local legal advice that we had on one of those projects was that the developers and the lenders shouldn't accept from a bank located in, I can't remember if it's Shanghai or Beijing, but it actually is in China, even city specific, because there is a sort of general concern that those banks don't pay out. They don't have the same reputational concerns that I mentioned earlier. If you were going to HSBC in London, for example, where they would regard it as it's a very sensible, prudent thing to pay out, because otherwise they'll never sell these things again. So that is an issue. And so what have we done to resolve it? Well, sometimes the contractors have gone to HSBC, I think, on that particular deal. Sometimes we had another one with ICBC, Chinese bank, but the bond was issued out of ICB's office in London. So, I would say it is an issue. You would have to evaluate it on a project by project basis. As I said, even within China, there's city by city reasons why you have to consider that in detail. That is a fantastic question, whoever answered that, who asked that.
Right. Maybe this is also a question for our arbitral institution representatives. I mean, have you seen disputes arising from, out of, or relating to favorite arbitration clause words, performance bonds? Yeah, Olena and Chris?
I will jump in here if you like. As I have seen in some context bonds, in the context of emergency arbitration, you mentioned that earlier, Robert, that once the call comes, and whether wrongly or rightly so, it's sometimes today this satellite dispute, as you mentioned, is very often the centerpiece then of your entire arbitration campaign, because now you have to act fast. Because if it was called wrongly and then the cash is gone, it doesn't really matter how successful you are in your underlying dispute. So emergency arbitration has become a very useful tool, I believe, to encounter those situations where someone else makes that call, again, as you said, wrongly. At least you have something in your toolbox as an attorney or a party to do something about it.
I might just add that from the institutional perspective, over the last few years, we observed a quite growing trend towards unjustifiable calls on performance bonds. And arbitration cases raised on that basis. But until recent, we didn't have emergency arbitrator proceedings. So all the injunctions orders were obtained through the courts.
Yeah. Yeah, this might be a good segue into, focusing our informed decisions from the performance bond to the international arbitration in Dubai and Saudi. Maybe, Olena, you as representing DIAC certainly enjoyed a lot of spotlight in the last half a year when it comes to international arbitration institutions. And I'd be happy to, put you right on the spot again. Before we hear from Chris, we should also mention here that when it comes to emergency arbitration, before we start talking about SCCA and DIAC, this is one of my favorite topics. And I think Chris has a professional past there. I mean, the ICDR was the one that introduced this, the American Arbitration Association's international division, on the international scale, and I have written a commentary on the ICDR rules, and what used to be Article 37 now is Article 6, and then merged into Article 7 of the ICDR rules over its different renditions. Seems to have been a trend-setting move that sees a lot of use in practice. So I'm delighted to hear that DIAC is also adding the emergency arbitrator to the toolkit of the user. There seems to be a demand for it. Can you update us, Olena? There was a often described aggressive yet progressive push for the establishment of a single arbitration center in Dubai. What are the developments? What's the recent highlights to report on this? What is DIAC doing to become the principal service provider here in the UAE?
Thank you, Martin, and thank you, the first panel, for such an insightful discussion regarding the bonds. Going back to the question, it's true that recently this decree, well-known Decree 34, which you already mentioned, has been a trending topic in the legal and arbitration community worldwide. Just as a little background, why it has been enacted and what was happening behind the scenes. As you might have known, that to some arbitration practitioners, this move of the Dubai government was a complete surprise, while to the others, they appeared to anticipate such a development. As we could observe, the UAE government have gradually contributed towards enhancement of the UAE arbitration landscape by signing the New York Convention, issuing UAE arbitration law, largely based on the model, UNCITRAL model law, and developing the framework for promoting foreign investment. 2021 was a very successful year for UAE and for Dubai. They had 76 billion of foreign direct investment in their economy. And with regard to arbitration, the Queen Mary University of London study of 2021 recognized Dubai as one of the top 10 preferred arbitration hubs in the world. DIAC, at this point of time, starting from establishment in 2004, remained the biggest arbitration center in the Middle East, with more than 3,500 administered cases and with a total value of claims exceeding far beyond $16 billion. So if we consider all this, then the ruler's vision for establishing one strong arbitration hub in Dubai has translated through this decree into reality.
Right. I mean, there's historic examples, right? I mean, I'm a German lawyer. I mean, in Germany, we went through the process of, what is now DIS having merged in the year 1992. Fair enough, this is the 1992 year. The American Arbitration Association is equally the result of a merger to have become the principal service provider dating back to 1926. So from that perspective, I don't think it's that surprising that, within a certain region, a single center has been promoted to just, to answer the market demands, I think.
And we trust that this vision of the ruler will really result in DIAC's enhancement of services and being the preeminent provider of arbitration services in the region. Regarding this merger, we just need to mention that that two separate entities, Emirates Maritime Arbitration Center and DFC Arbitration Institute, which had a joint operation agreement with London Court of International Arbitration, were merged into the new DIAC, the DIAC, Dubai International Arbitration Center, being completely separated now from the Dubai Chamber and having its legal personality and enjoying its administrative and financial independence. While the merger was not the easiest one, considering that certain separate legal arrangement existed between the entities. Anyway, in March 2022, there was an announcement of a joint agreement between London Court and Dubai Arbitration Center regarding the way forward for cases, ongoing cases under the DFC LCA arbitration, with the DFC LCA arbitration clause, as well as to the future referrals, which includes the same clause. So currently, DIAC start registering all the new cases which has referral to Dubai DFC LCA, and all these cases subject to administration by the DIAC under the new DIAC arbitration rules, which I think we will talk a little bit later about that. So all they started from March 2022. With regard to the ongoing cases, which remained, they remained with LCA, and LCA directly administer them under DFC LCA rules, but certain, of course, certain supervision from the DIAC, as it is mandated by the decree 34, remains in force, and a special protocol was agreed between LCA and DIAC on the payment matters related to the ongoing cases. Once DIAC receives from the LCA payment request to release money towards one of the parties or tribunal in ongoing DFC LCA cases, then following the review and approval, this money are transferred directly to LCA with further disbursement as required.
I see. So is it fair to say that as a result of the deal, the security, especially for those of us that see contracts that still provide for or have provided for DIFC LCIA arbitration, is provided? The path forward is clear now as a result of an agreement that has been reached. And beyond that, the existing disputes that were administered by LCIA have all been addressed. So is there anything left untouched, still providing for insecurity?
I don't think so. And the purpose of these arrangements and the reason why it might look for the communities that it took unreasonable time to reach it. But everything looks easier once all the difficult tasks are done. Was to maintain the integrity of the process and of the existing as well as new arbitrations, which had reference to DFC-LCIA. So everything has been touched by this agreement, and even those cases, there were 10 cases where during the period from the announcement of the decree, some of the parties, they made payment of the registration fee to DFC-LCIA. Also, these cases were never formally registered and no case was assigned. The clarifications regarding these cases were also issued by DIAC that these cases also fall under administration of the DIAC under the new rules. And the payments which were done will be credited towards DIAC new cases. It was very important that DIAC also introduced new DIAC rules in March 2022 to make sure that there is no gap as it used to be with the old version of rules 2007 and of course current rules of DFC-LCIA. So most of the provisions are very modern and reflect the need of community.
Right. Well, this sounds all like fantastic news. I'm glad we have you on this program, Olena. I had hoped to be able to do so and was quite happy that it actually materializes. That we also have Chris Alberti from the SCCA here, because when I keep hearing the word region, I'm wondering if we're talking about two regions, similar regions, overlapping regions. What's the SCCA's perspective on this, Chris?
Thank you, Martin and Bracewell, for inviting me first and foremost. Yes, I have to say congratulations, Olena, DIAC, and LCA. This was certainly no small undertaking, had far-reaching impact and consequences for parties and arbitrators. So this has been something that you don't get to see every day, and had to be taken care very carefully and very elegantly in order to get this resolved. And I only can wish for Olena and her team that this has been resolved. Same for the LCIH, to put this to rest and move forward move forward with business as usual, if you will. It has interesting impact, of course, for the region. I do not believe this will be too much of an impact for Dubai in the end. Yes, certainly you can probably call this an earthquake in a sense. For the parties, certainly yes, because some have probably thought about rewriting 10,000s of contracts. But the fundamentals have not changed. In my view, if you ask me what impact that has for Dubai, I don't think there is much happening after that. Of course, this is, again, as I said earlier, a quick earthquake. But Dubai remains an attractive seat. You have civil, you have common law regimes coming together here. You have an excellent location, international law firms and local law firms. Everyone's qualified. You have the finest arbitrators here. It is a thriving region. Generally, GCC, we'll get to Saudi in a moment, I believe, is a very thriving region. And if you think about this, I think it's worth noting that I believe from the 500 investment treaties that are currently in force in the Middle East, around about a third has only been ratified in the last 10 years. So there's a lot of momentum still happening here. So I was smiling when I read the other day an article where some suggested perhaps that maybe London could potentially become an optional, what do they call it, an international dispute sub for Dubai. I think that's a little bit far-fetched and likely driven by emotion. So, well, we'll give it to them. But again, fundamentals for Dubai are strong. Dubai remains very attractive. It's a good seat. And unless any, macroeconomic factors may take over, these fundamentals, in my view, will only become stronger. Same we see happening in Riyadh, by the way. It's a very highly attractive seat. It's a safe and mature arbitral seat and highly supported by government and also by judiciary support. If you were to look beyond Saudi and Dubai, Kuwait City is a fascinating area to look at, and certainly we should not forget Cairo and Oman as well. So there's again a lot of momentum, positive momentum for arbitration, despite sometimes little wrinkles happening. But I think Olena will probably agree with me. We'll have to look forward to make the best of it and grow what we all love so much, arbitration and mediation for that matter.
So when I'm listening to this, Chris and Olena, as an international arbitration practitioner and frankly also as an international arbitrator sitting regularly in this region, will I have to not only sit in Dubai and split my time with Riyadh, or will I be able to serve the region from Dubai exclusively?
Well, as far as SCCA is concerned, let me take the question this way. SCCA has a regional play, if you will, if not a global play. We are fairly seat neutral. So if your question goes towards what's the better arbitration seat, I'll be very blunt. As far as SCCA is concerned, it doesn't quite matter. We go where the client takes the case, and where the client, for all the right business reasons, decides the place arbitration should be, whether it's Dubai, Tokyo, Cairo, it doesn't matter. And that, of course, also then applies to the arbitrators. The seat usually has impact for arbitrator choices, no doubt, because just alone for cost reasons, you want to look to get arbitrators locally engaged. Now, these days, we have a lot of remote hearings that may become perhaps a little bit less of a factor these days. But it is also true that if you have chosen a seat, more often than not, you also want an arbitrator who's familiar with the laws or procedural laws at the seat. Most likely also choose the law of that country for the substantive dispute itself. So certainly this will have a factor in the arbitrator choice. But you, Martin, can sit wherever you want. If it's remote, it doesn't really matter. The only thing that you should be worrying about then is sleep.
Yes. Will I be able to help from New York?
Well, we had arbitrators from abroad, yes.
And Olena, I'll punt the question right over to you too. I think this is actually a line of questioning that's on the mind of not only one international law firm in terms of, predictions are always hard to make. But what's the place to be in the Middle East? Is it Dubai?
Of course, I might say Dubai, but not even Dubai. It might be even DIFC. This is the beauty of Dubai, that it comprises within one country, within one city, even two completely different jurisdictions based on different applicable laws. So DIFC, which covers the region under common mainly based on English common law, and our Dubai onshore, which is based on civil law, and currently, according to the decree, the default seat of the arbitrations when the parties fail to choose any seat would be DIFC. And the curial courts would also be DIFC. And this was something that was clarified by the decree, and the long-standing tension between jurisdiction of Dubai courts and DIFC courts was finally resolved. And but of course, as Christian mentioned, that there is nothing that can stop parties from agreeing on completely different seat of arbitration. We had cases with Paris, with Geneva, where all our rules can be also very effectively applicable.
Yeah. Well, the beauty of arbitration is that it is a matter of consent in many shapes or form. I mean, Chris, could you take us, not taking 90 years, but from the first reference of an arbitration agreement in the kingdom I'm aware of to what is now SCCA? I believe that time span of 90 years is really what it took, right?
Yeah, I'm not a very good history teacher, but I'll give you the short rundown if you like. You're absolutely right. I mean, arbitration has been around for a very long time in Saudi Arabia, but you're absolutely correct. There has been a very famous, perhaps the first on record, arbitration agreement signed by the Saudi Arabia's founder, King Abdulaziz, with regard to a concession agreement to drill oil in, I believe it was the Al Asa region. And fast forward, we had then seen an unlucky case, I shall call, for Saudi Arabia, the infamous Aramco case. Nonetheless, the kingdom has lost the case, but already the outcome, which was very important. But that kind of ushered in an era, if you will, in Saudi Arabia, where government was not so keen on further engaging in arbitration. Now, fast forward, since then, we've seen quite a transformative journey in legislative, executive, also judicial support to really develop the ADR industry. So in 1980, we have seen the accession to the Washington Convention. 3 years later, we had the first arbitration law. That same year, 1983, accession to the Riyadh Convention. Fast forward, 94, accession to the New York Convention. So all those those check boxes have been checked. And then again, fast forward 2012, that was an important year because that was the year when the new arbitration law had been enacted by Saudi Arabia. And that one is based on the UNCITRAL model law. So with all the gadgets that you know from international best practices. But that does not only work without the proper enforcement law, which was then also enforced or enacted that same year in 2012. So two very robust laws that really helped Saudi Arabia to kick off arbitration, give it new momentum. 2014 then was the establishment of the SCCA, that is us, by decree, and it took until 2016 where we then have been launched in cooperation and consultation with the ICDR you mentioned earlier, Martin. They helped us to really essentially get this ship off the ground right away and hit the ground running essentially. Now, but arbitration, to your question, really took off in 2019 by the issuance of a high order. For those who are interested, it's number 280044. That really signaled a shift in policy regarding arbitration with governmental bodies and state-owned companies, because that kind of reversed this decades-long Euro practice of prohibiting those government bodies to essentially having recourse to arbitration. Now, under this order, these foreign investors, the government bodies are now at least encouraged, if you will, if they wish to arbitrate, they can do so with foreign investors, but they have to obtain first approval by the Prime Minister. And then they have to pursue that arbitration in KSA, lucky for us under the auspices of the SCCA or any other licensed center. So that was really a key moment in time, particularly for SCCA, where we've seen a lot of interest from all the big companies. Next thing you know, we had meetings over meetings over meetings explaining that order, what it means actually for the market. Quickly fast forward, same year, another very important milestone has been the enactment of the so-called government tenant procurement law. It was very highly welcomed. It was another milestone to further reinforce the commitment of the Saudi government to facilitate a pro-arbitration environment for foreign investors. There are two very important articles in it. Article 92, again, government bodies can now arbitrate, but they only need now the approval by the Minister of Finance, which, as you may imagine, is a little easier than getting that one from the Prime Minister. And the Minister of Finance is very pro-arbitration. Article 154 restricts this to contracts that exceed 100 million. It's another very important milestone. We had a quick enactment of our own SCCA statutes to again reinforce what was already known, that we're not for profit, with administrative and financial independence, that the board is fully operational autonomously and so forth. And then last but not least, perhaps 2019, just to round it up, mediation exists as well. Everyone loves mediation. We heavily promote mediation. KSA has signed the Singapore Convention. So I'll leave it with that, but you see already there's a very robust push for an arbitration-friendly environment, but also with the other ADR mechanisms.
I should share this. I mean, what encouraged me to put the two of you together on one panel is actually something I heard about Alan Redfern when he was still a Freshfields partner. And that is, he said London will rise to a much more successful place of arbitration if we have more competition. Legend has it, that's how John Beechey started his international arbitration practice and what has now infamously become Clifford Chance's reputable practice in this field. So I thought putting DIAC and SCCA together on one panel might help by fostering competition and growth in favor of more international arbitration. Let me turn on on maybe a key feature of the set of rules that users are always very interested in learning about. Necessarily also because I think it only is shed light on in panels like this, and this is when there's a challenge to an arbitrator and the independence and the impartiality. Could you walk us through how DIAC deals with this, Olena, and how SCC deals with it afterwards? Chris, is this something that goes in front of the committee for administrative decisions? Olena, how does DIAC deal with it?
So the question is how the DIAC deals with challenges and impartiality of arbitrators, right, Martin?
Yes, indeed, how the challenge procedure takes place.
Yeah. So in general, so I need to start with saying that according to the Decree 34, which we mentioned already before, the new body within DIAC was formed, and it is arbitration court of the DIAC, comprised of up to 15 prominent practitioners at local and international level in arbitration, mediation, and other ADR services. So whenever we have any challenge or any objections towards impartiality and independence of one of the arbitrators, definitely this matter requires the parties' comments and the comments from the tribunal. And later on, according to our new rules, it remains the same 15 days we give for the party the right to challenge the appointed tribunal. And sometimes parties raised objections before the appointment of the tribunal, before the constitution of the tribunal, at the stage of nomination or appointment of one of the arbitrators, which is dealt a bit separately, and we call it just objection to suitability, sometimes also raised together with objections of impartiality and independence. And nowadays it is the arbitration court who decides on these matters. All the members are involved in decision-making process. Of course, if one of the members is conflicting, this member will be recused from the decision-making process. And in accordance, again, with the new decree, there was a new obligation of the DIAC to provide reasoning of the arbitration court decisions, but only in cases where the challenge is accepted. Mm-hmm. Currently, under the new rules, we haven't had yet any challenges raised, because all our ongoing proceedings, they run still by rules of 2007. And also it is an important fact that sometimes we had cases where, following the decision of the of the previous executive committee, was the body who decides on challenges, the unhappy party raised the same challenges in front of the UAE courts, for example, we say about Dubai-seated arbitration. And in majority of the cases, I think even in all of the cases, I won't be wrong to say it, that the court never always dismissed this kind of challenges by the parties, and based on the absolute right of the institutional body to decide on these matters. And of course, for all such matters, we always cover the legal expenses of the arbitrators, for example, who are sued by the party in the courts.
Okay, yeah. As a full indemnification for the arbitrators. Would the arbitrators be heard in this process? Are they invited to comment on challenges from parties?
If we talk about the DIAC process, challenge process, yes, of course, the arbitrators must comment, and these comments are always shared with the parties.
Okay. Of course, this is one of the areas where the community is always interested in the utmost transparency, understandably. And it's a continuous push, for the institutions to be careful, to preserve the integrity of the process. So there's sometimes competing interests. But with that, Chris, is this something that goes in front of your CAD, the Committee for Administrative Decisions?
Indeed, and you said it very correctly. The integrity of the process is kind of what we are supposed to do and are tasked to do and observe. That is sometimes a little bit tricky when it comes to balancing that with party autonomy, but the idea is here really that the institution itself is the guardian, if you will, of having the integrity protected and ensure that the outcome is enforceable. Now, to take perhaps a little step backwards, just a little bit, we do use very frequently the strike and rank list method, if you will. That is, if parties do not come to us with their arbitrators already chosen, or party selected arbitrators, if you will, they get a list with full biographical cards. So very often they already know who they're buying into by striking and ranking. They can eliminate all those who are perceived to be in conflict. So that reduces already to quite a wide degree the ability to even challenge an arbitrator, because you know who you're buying into, you know who you're striking out and who you rank. Now, past that, if then the disclosure comes, as with every institution, I would assume, if the disclosure is vague, we dig. We go in, we go back to the arbitrator and ask questions. And I remember a recent case where we never heard back from that arbitrator. Next thing we understood, the new arbitrator name was proposed. And so, mission accomplished. It's sometimes funny how that happens. But yes, once the challenge arises, then of course the other side will be heard. On occasion, the tribunal does know there is a challenge. On occasion, we also reach out to the affected arbitrator to get further information on specific questions that we may have, because we indeed, as you said, Martin, we send it over to the so-called Committee for Administrative Decisions, one shortcut, which is a committee of 5 members that is doing exactly that. They decide challenges, among two other things, and they have to be educated as best as we can make it. So if there are any open questions, and we had this on 2 occasions, the committee comes back to the SCCA secretariat and said, go back to the arbitrator, ask more questions. We did that. Information was shared with the parties, more comments, and back to the cut. Now, you may say this take a lot of time. As a matter of fact, this always results in less than 14 days. So we also try to make this very quickly, because it's a very, very disruptive moment in the time of an arbitration, particularly when this happens, in the second part of the process. But this committee is highly capable. We're very blessed to have a former LCI registrar in it. We have a former ICC Deputy Secretary General in it, former SEC registrar in it, myself being the former Assistant Vice President of the ICDR, and also a former Chair of the Board of Directors. So we're talking roughly about 40, 50 years of experience, hands-on experience with exactly that topic, having done the subject matter for a living, if you will. Now, it is always a little bit of a challenge, but we had so far with this new committee since 2019, 4 challenges, and it was an even split. 2 got removed and 2 have been reaffirmed, and we move forward. Perhaps in closing, we had a little bit of an unfortunate situation last year that I don't say with pride, but I say it's because I think it's important to also mention this particularly to arbitrators, to ensure things go the right way. As many other institutional rules, we have an Article 14.2, that allows the SCCA on its own initiative to remove an arbitrator if we then perceive that arbitrator not to performing his duty. So failure to perform the duty, that's kind of the standard, if you will. And this has been a very unfortunate scenario where we had to step in essentially on our own terms and not sit idle by, but take action. And we removed that arbitrator. It was a very disruptive moment. No one wins in this, but it had to be done. And again, if anything, it shows that SCCA has teeth, and that we just don't sit, as I say, idle by, but rather, going back to the original message, ensure and protect integrity of the process. That's our main thing to do. And sometimes, you have both parties being unhappy about this. Not in this instance, I have to say, at least both were sort of happy about it, but in varying degrees. But in the end, it was the right thing to do for the case, and the case has been awarded with a substitute arbitrator who was very quickly appointed.
I mean, I want to give Ibrahim a chance to weigh in on Saudi courts versus Saudi arbitration as well. I think that might be of interest to the audience. The one thing I want to say is when you get challenged as an arbitrator, it's always a very peculiar moment, and it's always good to be in the hands of a good institution. In my case, the allegation was I was in a business partnership with one of my co-arbitrators because we had co-authored a book. That co-author and I, we were amused by it, and we said we should tell our wives that, our business partnership is not paying great dividends, quite literally. So the institution decided in my favor, overruled the challenge, and the proceedings took their course. But it's this kind of thing that surfaces in this context sometimes for pure strategic purposes. Ibrahim, before we run out of time, should we go to advise our clients to go arbitrate or to go to use Saudi courts? What's your answer to this very broad question?
Thanks, Martin. Just echoing what Christian was saying, the SCCA, the Saudi Center for Commercial Arbitration, really kicked off in 2019. And since then, around about then, for the last couple of years, for the last few years, we've regularly advised clients on whether to opt for Saudi courts or the SCCA arbitration as the choice of dispute forum under contracts. Of course, we discuss these issues with our litigation colleagues and take into account the nature of parties, potential disputes which may arise under the underlying contracts, as well as potential enforcement issues. But there are other general considerations which we also recommend and discuss with clients, and we recommend that they consider when making this choice. One of them is governing law. So in an SCCA arbitration, you can opt for the governing law of the underlying documents to be English law, whereas if you were opting for Saudi courts, that is not an option, as the courts would almost always apply Saudi law to any cases that are in dispute in front of the courts. Another difference is the ability to appoint subject matter experts. If a contract is related to a construction project, for example, you do have the ability to choose the arbitrators, as Christian and Olena was saying, who may have the subject matter expertise on the dispute. Whereas if you were to end up in Saudi courts, this would not be the case. You would, of course, be unable to pick the judges and would be unlikely to have subject matter expertise. There's also the cost consideration. I think it is fair to say, maybe Christian may disagree, that bringing a dispute in Saudi courts is cheaper than pursuing arbitration. Having said that, the regulations on bringing claims in Saudi courts have very recently been amended, and claimants for the first time need to deposit a certain percentage of the claim amount. I believe it's up to a cap amount of the court as court fees. They need to deposit that amount as court fees. No doubt this will change the dynamics and potentially reduce claims generally in Saudi courts. And in terms of what we were discussing in terms of market trend and shift, I think with the establishment of the SCCA, there has undoubtedly been a shift in adopting arbitration instead of Saudi courts in contracts, and I think that this trend will only continue.
Yeah, we strategically left Dubai for Olena's recommendation of DIAC arbitration, which is not to say the absence of those that would advocate for DIFC or even Dubai courts is something to consider or not to consider. I don't know if Tom has any opinion on that, but as we're approaching our full time here, I don't see further questions. Can I invite every speaker for very brief closing remarks? Mine will be thank you very much for having taken the time to present here and share this program with us. And we look forward to hearing you at tonight's, seeing you at tonight's reception. And for those in the audience that can come, that would be a pleasure too.
Cool. So I'll give everyone a couple of takeaways. This is sort of magic dust as a sort of as a thank you for the attendees. It's, gold standard legal advice on performance bonds. So two things I would say: if you are expecting your performance bond to be on demand and it says bank guarantee on the front, then you should change that and make sure it says on demand bond, because the calling something a guarantee is evidence towards the fact that it's a conditional instrument, not on demand. So, as I said, the construction market talks about bank guarantees from a legal perspective in your contracts, in your term sheets, in your bond itself. Please talk about bonds if you want it to be on demand. And the other little bit of magic that I would offer you is, as Rob said, if it's an on-demand bond and you make a call on it, somebody at some point is going to look at the underlying contract to see whether there are conditions for calling the bond. As a good and thorough and diligent lawyer, you should be going through the construction contract, and wherever it says, if the contractor doesn't pay liquidated damages, you can call the bond. If the contractor breaches this, they can call the bond. You can delete all of that, because your on-demand bond can be called in any circumstance, and you do not need the contract to tell you when you can call it. And if your contract specifies when you can call it, circumstances when you can call it, that implies that there are circumstances when you cannot call it. So you should go through the red pen and strike all of that out.
That's a lot of golden dust. Thank you, Tom.
Honestly, these people don't know how lucky they are, Martin. That really is top quality.
Indeed.
I'm not sure I can offer that much gold dust, but just building on what Tom has said, if you do find yourself in a position where you have a dispute and you're holding an on-demand bond, start thinking about the strategy and procedure for calling it as early as possible, because some of these EPC contracts do have, convoluted claims mechanisms and notice mechanisms, and this is not a decision you really want to be making overnight. You need to think about it, and there should be a plan and a strategy behind it. But with that, thank you very much to everyone for listening.
Thank you.
From my end, I would just add probably to the party that when drafting their agreement, they should pay very good attention toward the arbitration clause and make sure that they opt for the institution they're confident with and which exists. So, and anyway, thank you very much for having me today and for having this gender diversity in this panel.
Kudos go all to you, Olena. Thank you. Chris, you've got the last word.
Oh, that's excellent. I stick to Tom's and Rob's duster theme. So I think in closing, I would encourage everyone to look again back at the fundamentals of Dubai and perhaps move on with that discussion as to whether or not Dubai is a safe and mature place. It is. I think it will be only thriving from here onwards. Same with Riyadh. It is a reliable, mature, and now very safe place to arbitrate. Having more time, I would tell you more about our survey we did last year. We found out that only 6% of annulment proceedings were actually successful, which is way under what you internationally would otherwise see. And of those 6, only 3 have been based on Sharia, which is another thing that for another day we can discuss, that this is not something to be fearful about arbitrating in Saudi Arabia, if that becomes a factor at all. Thank you.
Before we know it, we've got DIAC arbitration seated in Riyadh, and we have SCCA arbitration seated in Dubai.
That will be a perfect ending.
Well, thank you very much, everyone. It's been a pleasure.